Maybe the lot I an item for 30 or 46. City has not been received. Yes, madam.
30 cities not a direct process.
Any
Can
query?
No,
Your
you not. It can be on first week of October, any day.
It really
Lordship, 5th of October.
is so. Oblige.
Okay.
May the lot I remember item number 15 million. 1515 dotted. Yes. Yeah, done for 1 week, my lord.
Have you informed RSA?
Actually, I have not informed because of
You repeat it. But
actually,
no experience.
People listing a page
When?
tomorrow.
investigate of item number. It was called.
Item number? Yes, madam. Any interim?
No,
No,
What?
on 6th of October.
by the right of part 1.
Yep.
City was for
31 cities not available.
your
Interim?
lordship on
Any interim?
no your lordship. Similar connected matter your lordship on the same application to bail application purpose. As it was listed on it's been listed on 29 along with city and
Along with?
city and
Huh?
or
Along with?
or 3046.
AP 3046? That's 20.
Okay, by the for update case with 21 cities available.
So it's better after that. It is there.
Yes, it is. 22 and
Number?
22, 23. He is not.
Interim.
22 lordship cities not available. Petitioner is an interim.
Vote 2020. Vote interim.
Yes. Then
When?
38. 13 October.
30.
Then 30th of October. 30.
No, October is the holiday change. 7th of November.
Lordship.
Lordship, so 38, item 38. The engaged counsel is at difficulty today only. Any day this week.
30th of department.
Have you taken get you after we connected?
Interim order.
Yes, your lordship. I beg to mention item 20 not. It is not available.
20 cities not there.
Any interim?
Interim is there. Interim may be
Interim continue 5th November.
Then 5th of October.
9.
9th of October.
Highly operator.
Where interim sir, they are now there
November.
will be huge rush. Why?
Wait.
Interim
Yes,
they
9/11.
Okay.
the bail receipt, court attended application. Petitioner was arrested on 10/8/23 receipt. Election under section 40637.
when city
Lordship city on 5th.
city
7 is also similar. But nothing has been recovered from my property.
City
you know it city.
on 4th of October.
Then 7 also similar. 7 is similar. Much obliged. Much.
It is a lordship.
City
Lordship on 6th. Lordship postmortem. Yes. PM report.
30
Should be a part
along
of
with
it. 6th of
Is your part. Lord, 413 bill application, my lord. I am behind bar for 993.
Send copy of the case diary and the statement of the chief, including the case diary.
Status report.
LCR.
Can go. You are dead.
Apo.
Then
Lordship. Applicable lordship.
CD.
TP postmortem report. On 9.
CD.
The lordship, my understand is filing an application under section 438, lordship, 439, and his grievance is lordship.
In this case, my lord, petitioner is shown arrested. In the main case, he has already been released by this honorable. Lordship may keep it down. And that after lordship,
Where is the what page
My lord.
14?
my lord,
You are arrested on page 14.
lordship, what has happened?
No. What is happened will know from the FIR. Tell us which is the FIR under which you have been arrested. Page.
Yes, first,
14.
yes, lord. Page 14, lord. That is the present after. During the when petitioner was arrested in connection with
You
one,
are now shown to be arrested in lumping case number 173 of 23.
yes, lordship.
Isn't it?
Yes, lord.
To the satisfaction of
Lordship, Pujai Sampanna.
SDM.
Deeply object.
My lord, husband is before lordship. My 2016 marriage at 38 days.
Option is marriage. What are the
Education, my lord. It's a day of Eid, my lord. Because
302 is there.
there is teacher two, I think. Oh, no, that case number is
case number is 302, my lord. My lord, actually.
FIR is a page 10.
Yes, yes. FI is a page 10. They have a child also, my lord. Probably there will be reconciliation also, my lord. RDR.
To the satisfaction of
CJM Lokhimpur, my lord.
SDM Lakshmipur. Consider that.
The judicial magistrate Lokhimpur. Obliged, man. Second bail in
For your happiness, CD.
CD lordship 1/5 of October.
Not 5th of.
The 9th.
Put that date petition, my lord, your lordship will turn to page 8 FIR. So, my lord, mother-in-law is before your lordship. So mother-in-law may be in the interim may be protected and city may be protected. Because my lord, allegation is
1
against
year, 6 months. Serious allegation of torture continuous. And on that date, on before suicide specific allegation.
Yeah.
307.
No, my lord, your lordship would be pleased to see allegation. That is, if there is allegation directly regarding demand of dowry, then matter would have been separate. But here allegation is this, my lord, the father-in-law attempted to rape her.
No.
So, my lord, yes,
What is the FIR? Tell
yes,
us.
FIR at page 8. So, my lord, my humble submission before your lordship, Not it is a clear case of dowry debt. Forceful rap is the main thing, man. So rap attempted to be committed by the father-in-law, not by
Where is your
Mother-
statement?
my lord.
Eight is-
Kamarhat police.
Specific demand of dowry is there. Why
Yes.
are you saying no dowry?
My lord,
I got
no,
myself.
I'm not saying that there is no demand of dowry. But my
You
humble
said, had it been demand of dowry, it
No,
would
my
have
lord.
come.
part
What,
say,
what does it mean?
my lord,
It is
my humble
specific
submission
demand of
before
dowry. I got myself.
my lord, let me place.
Yes.
My humble submission before your lordship is this, that if it is a case part say demand of dowry,
Hmm.
then matter would have been different. But
So it
here
is
in
why-
this
what-
case, my lord,
Hmm.
here in this case, your lordship would be pleased to see, I heard from my daughter that the accused number one sometimes forcefully tried to
Okay,
rape my daughter.
minus that. Delete that.
My lord, my
Delete
humble,
that. We are
My lord.
deleting that.
my lord, my humble submission before your lordship, it will not be proper to delete that allegation. That is the main allegation.
No, that is not the main element.
Yes, my lord.
No.
Forceful, if father-in-law forcefully tried to rape a daughter-in-law, and demand of dowry, my lord, that will be settled down. In that case, my lord, the mother-in-law may be protected for the time being.
On 9th of October.
9th of October. Apply, sir.
CD interim.
Apply.
Yes, Lordship. 9th of
The product case, statement within 10. It's a case of absolute bail. Why should we,
9th death.
yes, madam, it's a case of absolute. Absolute.
Thank you.
Yes, Manan. CD.
Lordship, earlier.
No
what you were
interest,
raising-
no interest.
No, I was just pointing it. Lordship has seen both the FIR. First FIR, kindly see, where we have filed it first. And then all the whole allegations were made on the basis of our FIR. That is what I am trying. Just kindly see my first FIR, which I made. That is at page 50. 50. I have given all the amount that has been taken by that woman from me.
Yes,
Yes.
yes.
First, your lordship will kindly see page 18. Sorry, page first complaint your lordship will find at page 53. 50. This is mine. Why I'm saying your lordship, because this is the case we have filed.
Yes, 50.
I have filed this your lordship against the complainant in this case. Present, we have filed this. First, it has taken about 7.5 lakhs from me in different dates. I have given the copy of the whole bank statement from the beginning.
What is the new ground?
New ground is that your lordship, with regard to this part, your lordship has only taken into consideration 164 of the statement of the, and this statement I have brought it. Her first allegation was I have taken money from her on a particular date. That same day, your lordship, she has taken money from me. That is on the bank account I have given. So she is telling lies. False. If I am taking money from someone on the
Okay,
same day, which
Okay, when can you have it?
Lordship,
Earliest.
on 29th. Then Lordship
Can you have it on Friday?
will,
From which place?
it will come to Metro.
what?
Not,
25th or
no, you have it on
26th.
otherwise it will go to 9th of.
What?
We'll try on 22nd.
Lordship.
FIR is as your lordship.
CD.
Your lordship, may I play your lordship? It was in log, a tag here, can it be passed over for the time?
Your lordship.
Your lordship has directed the to obtain instruction.
Yes, Thakur was there. We asked for the status report, whether
Just
vehicle
after some time after whether it's
Or
heard the K. Goswami learned senior counsel led by the D. With the PK Putta. Also heard when the present application under the 482 of the Code of Criminal Procedure 1973 is part for quashing of the affair in connection with Dibrugarh Police Station case number 415/2023. The allegation, where is the
My lord, page 44.
the allegation level in the present the affair level which is under certain relates to uh, death of a person due death of a person during treatment, more particularly during operation. Full stop. Such operation was conducted by the present petition. Full stop. Present petition. Considering the nature of allegation, the court is of the view that the case may at best a case for negligence, and from reading of the affair, no prima facie case against the petition made out. Inasmuch as the Honorable Apex Court in the case of Jacob Matthew versus
2005 651,
2005
volume 6 SSC, page 1.
has provided that the doctors in due course of their service, if any negligence there could not be straight away arrested or affair should not be straight away registered without making any. According to court is of the view that the petitioner is able to make out a prima facie case for state. Accordingly, the further investigation, Dibrugarh PS case number 20 shall be.
Deeply obliged, my lord.
Any information? Informant is a party.
Restatement number 2.
Notice within 5 days. Except for one, other for
The only thing, my lord, the death was not during the operation, post operation.
Okay.
Deeply.
still returnable.
6 weeks.
Yes, Your Lordship, but suppose that in an application.
Now,
LK was solved for.
yes, Purva,
LPR received.
what is the matter?
As per statement, deposition statement of the victim lordship, allegation against a maternal uncle of the accused person, not to the accused person, the present accused.
Have you
Okay, sir.
seen
Yes,
our
of course,
cross-examination?
my lord, that I have said, sir. My lord, also the examination in chief lordship, the two questions put by the trial court.
Trial. First part is that, okay, that may be an explanation that she is now married. But for whatsoever reason, at paragraph 28, he has said it's not. He tried, he proposed to have credit, he refused, so he
The second notice, as per the queries made by the trial court, notice, he has said that
but
he
in
was,
cross, but in cross,
yes, so that I,
can convict a person on that. Who are you? You are the husband.
Yes.
How many days you are in?
180 days, 189 days.
Huh?
189 days.
Be there for some time. Why have you done this to this girl? What was her age?
at the time of marriage, 19 years.
Her statement is recorded. How many are witnessed that?
Up to the 9.
Huh?
9.
Others are not important. She
The main witness.
is the main. Or you are Mr. Garnet Counsel. The present application filed under section 439 for grant of bail to the petitioner who is accused and other custody in connection with session case number 39 bracket NL 2020 pending report of the Garnet edit. The this court under its order dated 8/8/2020 call for LCR along with the deposition of witness. The same has been received. Kerut the same. The girl, the victim lady has thoroughly been examined and cross-examined by the from the perusal of the material of record. He is the star witness for the and as she has already been examined. It court is examined and cross-examined. It court is of the view that there is no scope for difference or conferring or tempering evidence. Further, from perusal of the testimony of the girl, it court is of the that should not be kept under further it has much as the required from according to the that allowed the petitioner to take the pay of furnishing of 8,000 or other conditions not paper or not try to contact with the
Obligation.
additional expenses.
So 17 years.
Yes, Asmat Ali,
Not received the case diary. No.
is there not received?
Punapur, you can pick them at the PL.
302.
Yes.
When? How many days you are inside? When, Borwa?
That will be on my 27.
this man is doubted? What is your case?
My case is that, my lord, me and my,
Out of the whole world,
Well,
why
this
you are doubted?
this is, my lord, working together, my lord, in a dump. That
In
is
a-
why- In a dump, man. That is
Okay.
why, my lord,
But that the
You
case
have
that-
a, because purely on suspicion.
Right.
You have the case that you would speak.
27/9.
hello,
Is that page 9? By the search is submitted,
They submit SP 76,
my lord.
being 30 number.
Search number 15/2023, dated 31/8/2023.
Reported in the party to approach the trial for grant of the survey. In the event that application is filed, then considered. That's all.
Please, Your Honor.
17 years,
Yes, sir.
366 days. It is there.
Case that is not
case missing case. And
Reporters is recovered.
both are recovered from the new Wagner.
Where is that?
Worship,
Where is that? What is your age?
worship, my case is, I am in,
What is your age?
my age, worship, 30.
28, Lord.
Is 16, you are 30.
Completed age is the 18 of this month.
Then also you double the age. Had it been in 19, there may be a
28.
good after that.
28/9.
Happy. Postmortem report.
Postmortem report is received, Lordship, but the allegation is that she consumed poison, Lord. The FSL report is not.
Where is the affair? You wanted an adjournment in this case, the morning.
But the other person through and through, they were protected by law. They appeared.
No, no, let us see, let us see. Where is the allegation? You are without a brief. Where is the affair?
Page 14, Lord, the
No,
Bharat.
no, paper. Where is the affair? Why have you then joined advocate status? The in-laws are granted it.
The accused number 1 is the husband.
Any name, any neighbor, neighboring.
Neighboring witness is not against. They not said
What?
any picketing. Only Lord, the 304B, Lord, they are pressure of the FIR. I have not found it. Let him appear, Lord, in the meantime, Lord, may call for a up-to-date case.
Now what should we record? None appears to the forward of the so postmortem is available, which indicates that the victim consumed poison. However, the FSL report is not available. According to method test, the adjourned enable consider the matter, considering the matter material collected so far against the present difficulties of the present material according provided that it can be put up.
One thing, Lord, the postmortem report does not suggest that she consumed poison, Lord. Allegation is that she consumed poison.
What is the purpose of report?
My Lord, only my Lord, my Lord, final remarks is pending.
Finally, my finding that what is the cause of the no other injury, nothing
No,
of that.
no such injury.
Put up, as the cause will suggestive of poisoning, poisoning nearly. From the postmortem report, it revealed that there is no injury and allegation is of suicide in terms of the affair. Therefore, the as per the postmortem report, the cause of death could not be determined according to the what you call it, the
Visceral and
uh, then for its examination. The report according you appear before the ION record
let it be, my Lord, 15 November.
50. Yes, Mr.
The 438 application, my lord. The case is registered under 376, my lord. Your lordship will find the FIR at page 7.
You are
I am,
Rafiqul.
yes, my lord. Most respectfully begs to state that in approximately 1 year, the above noted accused person came to my house and committed physical relationship by showing temptation to marry me. On last Wednesday in the evening at about 6 p.m., the accused person carried me to his house and promised to marry me. After that, the family members of the accused sent him from there to some unknown place. Started from. But I have narrated my facts, my lord, at page
164. Yes, ma'am.
He wanted to marry. The brother and the brother-in-law. He has no bad in. Yes, they can start. But what to do with family member beaten up?
because they are of the same faith.
Now he is suffering.
I was not in faith.
He appears
You're
in my
interim,
report.
Considering the material so far collected against the victim, including the statement of the victim recorded reflects that the victim has not been alleged rape of one part by the present. However, there are certain allegations of beating up by the brother and brother-in-law of the present. This court has also considered that report considered that the victim who are after interim protection granted that report court considered that no custodial death according to interim order of earlier.
I'm deeply offended.
Marry her and go somewhere else.
But
None appears for the petitioner or all. None is represent the petitioner when the matter was called on 39 according to present application that is for one. Is there is there?
Okay, there is no 25.
What is the affair?
They
Huh?
have page number 8.6.
Page?
Very good. Very good. So the is that of the night of
You are accused number 1 or 2?
both
Both are here.
to the that on the night of 5/23 at about 12 o'clock, the domain accused number 1, the direct connivance of accused number 2 to me from my house of accused number 2 by luring me to marry, and the accused persons are forced to me without my consent in the house of accused number 2. That same night, the accused number 1
Just a minute. This appear BA.
Some of the witnesses stated
So,
they are
everybody,
married.
not some of the witnesses.
Yes, madam. And subsequently she also refused medical.
This diary carries produced statement recorded by the statement recorded. Statement of the victim recorded under one. All the other statements of other that the appearing input of the student. The custodial interest present or recording. The method recording present or
deeply
She has been pressurized.
what happen is moment you see this kind of case diary, your mind is influenced that these are all cases are false,
Yes, yes. Most of the cases are like this.
like these one. Yes. We'll go to the interim was interim without now who was the affair.
She did not.
Did you not receive?
and for the IOR.
But the case diary called for it not. This matter
It is
after vacation.
after vacation. It is
9th of
30th.
13th of 14th of November 20 for product testing. Dairy motor contract. Yes. Time being. What is the case about? You know, there is no time being, more specifically when juniors are here. Why you need a senior?
Yeah, please. Chapter 38.
What is your name? Saiful.
Yes, please.
You are Saiful.
Yes.
Already searched.
Statement is 10 copies also
That is
to be received.
Already searched. Under section.
Oh, yes, yes.
You don't know.
Yes, yes, my lord, my lord.
Huh?
Sorry, my lord. My lord, under section 366.
You have taken responsibility of a person who is behind bars, and you are doing your homework here.
My lord,
66, why not focus?
actually what happened, my lord? Uh, there was a love affair, my lord, in the victim girl and the younger brother of the present petitioner. And my lord, the younger brother of the present petitioner already married the child. They are, my lord, living as husband and wife, the same court. My lord, when my lord, the incident was took place, my lord, the younger brother, the present petitioner, was accompanied him. And charge sheet has been submitted, my lord, against him, not the, my lord, younger brother. My lord, specific allegation is there, my lord. My lord, kindly see the FIR.
Who is Sophikul?
So,
According to her, Sophikul put it taken. Sophikul is brother, or you
brother,
are Sophikul?
no, my lord, here, Sophikul is the present petitioner. And my lord, Zohar Ali, their father, Amir Ali, my lord, is my lord, younger brother. And Mary, my lord, has been solemnized between the victim and the Amir Ali. They are, my lord, living as
So
husband and
Sophikul is aggrieved. Or what?
Tartik, no agreement. Tartik has been submitted against the, my lord, Sophikul.
Because allegation is against Sophikul.
Two also, my lord.
Huh?
My lord, against the two also, my lord. Kindly
So
see the FIR.
since is only against Sophikul,
As well as, my lord, accused
this
number
is
2.
not a place to grant you bail. There is specific allegation.
My lord, kindly see the FIR. My
FIR,
lord.
where is
Both
the
of 1
FIR?
and 2, my lord.
Huh?
Page 19, my lord, particular.
Page?
এজাহারকারী সন্মানপূর্বক বিনীত নিবেদন এই যে 16/11/2018 তারিখে আবেলি প্রায় 4:30 বজাত নিম্ন 1-2-1-2 নং পটকিয়ায় মোট 16 বছৰীয়া নাবালিকা ভৰ্তি মিস enter
Huh?
his appearance, my lord. Until, my lord, enter his appearance before the court, my lord. Examine the
Have you filed bail earlier? Then you go and appear. What happened to the bail application filed? Why are you saying no? bail application filed before the, under section 438, before the ad hoc additional session judge Dorong at Mongoldo. What happened there? You know nothing. Then why have you filed this application? The learned counsel could have please submit that. But is it AP? I thought BA therefore evidence of that AP also is not to approach the step. What happened to your AP? Tell us that statement is required. What to do? See, we are wasting so much of
Madam,
time.
let it come next week, madam.
You file an application before the additional session judge, which is registered as Miss within bracket B case number 196/2022. And it was fixed on 21/5/2020. What happened there? Is it not necessary to make a statement?
I'm not there.
Why should we not input or for withdrawing material facts?
Let it come next week.
It for you harm. These are misconduct. A person is apprehending arrest. Rightly, wrongly, we may allow him, we may not allow him. He has come to a lawyer chamber. If this is the way a lawyer is prepared, according to us,
Madam,
please stop that preview.
NBW,
Oh, well, he must have given a statement, na? They already rejected. We need to see why the session, the court has rejected his anticipatory bail so that we can apply our mind.
that's what. After
After
oblige.
Mr. Go to and check mark that there is an application. They file an application that because warrant was issued, they file an application saying that this dispense with our appearance as already a bail and bail application is made. Their application is in on record. You go to it. We are not happy.
Yeah.
That
So-
much we can say. Yes.
Oblige.
Next. Yes,
438 application. FIR is at page number 12.
it is page number
Clear.
12.
Page number 12. And it's dated. Okay.
What is the method? Girls are recovered.
Girls are
Two girls.
recovered. My lord, regarding this petitioner, my lord, actually two girls were, allegation is two girls were abducted at that time. Subsequently, both were recovered. One girl expired and one accused also expired. And
You know how the girl expired?
that regarding there is one postmortem report, my lord, because it's a case of 2009. That is not conclusive. And regarding this accused, my lord, the victim has reported her 1624
What
statement.
what is her statement?
She stated she is willing to stay with.
What is her age?
Now, my lord, she is perhaps measurement. There is no certificate. Record is certificate.
The case of 2009.
2009. Yes. That is the one.
Then what happened? Have you married this girl?
No.
Then why have you taken? It's married.
Equally 376 was added.
You have received someone, but
That's it.
not that.
Not certain.
That's very totally report. Statement of the one of the report. They are state but not present in as much stated that that and is the put it up that it- what it- it- record the statement.
Idea.
Put at the application.
File is 80.6.
07/3/26.
For Nagaon by the on by the 26.
Yes,
Where is the page? Patil?
it is there.
Okay.
When it's no intent, like
29. 37.
Then
written.
before that 20,
20.
including
There is no
my lord, the allegation is 326, my lord. However, my lord, to my instruction, my lord, there was a land dispute which is there is a mention of that even in the FIR itself, my lord. And my lord, there was some altercation and he fell down and he has received an injury in the forehead. But this weapon episode, my lord, three weapon being carried by one person, my lord, this is an exaggeration. My lord.
Materials collected are all against him.
the anticipatory bail proposition has reached a different. My concept is something different. Now I am learning. My idea was that privilege. Anybody, it is not for anybody. Kill person, some with rape, minor, Some
Because my lord, previous injury otherwise is 325, which is payable.
previous
My lord, if it is a previous injury, even if I take that as a fact without contesting, even then it is available of 325. The only thing, my lord, will make it non-bailable if there is a recovery of any weapon. That is only when it will become non-bailable.
are we doing a trial?
No, my lord, because since it is the issue is bailable or non-bailable, my lord, and I am appearing, my lord, in a bail application, my lord, and therefore, my lord, I am making this submission. So, in the absence of any weapon, my lord, this cannot be registered under 326. There has to be seizure of some weapon. That is my instruction, my lord. There was a land dispute which is there, which is mentioned in the FIR itself.
Don't bring land dispute.
It is there in the FIR.
Land dispute will not permit anybody to.
Absolutely, my lord. I am not saying that, my lord, but at the same
Day
time,
before yesterday, the case was that a lady said, I am a widow. Widow, I have discussed my only house is burned, and it's with benefit. And the ground is that that land belongs to the accused. He has got a decree in first trial court. Decree was affirmed in first appellate court. And second appeal also the other that widow is not appearing. So it will be dismissed. So he needed. Will that permit the person to burn a house? There will be execution.
if he has done so, my lord, then probably that will not warrant. But if
Maybe
was
he
not
might
there,
have gone in Supreme Court also. He will have to execute his decree and say, can he burn down the, because he thought that I will win the case. And execution will take another 10 years. Better burn it.
my only submission is that, my lord, in this case, my lord, that his weapon thing is been exaggerated, which is also evident from the fact that how can one person carry 3 weapons, man? It's not
We'll see the what the statement of the, will not believe either you or the, we'll see the what the other people.
yes, my lord, if it is, if there is any independent witness, my lord, yes, my lord, lordship, who, if they
Who,
testify
what is the name of the informant?
on informant, okay. My lord, the name of the informant is Jogati, no, Oruni Bora.
Okay. We will not read her. not called as sweeper, only a sweeper. You are correct. He was not carrying so many whips. He was carrying only a sweeper. That has been used.
That has
Now-
been seen. Because, my lord, I may be wrong, my lord, but I'm making submission on instruction. Because he is saying that no weapon was there. There was some dhakka dhakki, my lord, that is true, my lord. He received injury in his forehead, but no weapon was
The witnesses said that by the Uthar or Nath,
sense of very there of that be hard to
Investigation is going.
Huh?
Investigation is going.
accept.
one witness, we have minus. He is the nephew of the. We have minus the statement of the wife of the other neighbor. Everybody said there quarrel between
Quarrel.
them.
Quarrel is-
So far relating the boundary. There was a demarcation that with that thereafter the one for the started topic, then from where Nal Puthar or Nal was and injury report still reported if you are still following. So do you think that this is a case for it? Why you leave it to
But I argued my case on the point that there is no seizure of any weapon, my lord, at the airport. My lord,
considering that it and including medical test report of the case where the right spot privilege of fear.
different districts, my lord, different persons, but coincidentally the sections are identical. Now here my different district, different persons, but I coincidentally, my lord, sections are identical. My lord will kindly, because there is a cross case, my lord, and in the cross case there are 5 persons named and
This
4.
page 15 is filed by
Relevant FIR is page
Yes,
8,
filed by my side.
your 11A.
11.
yes. My son has
And
filed.
where is the other?
Other one is that page
Other one
8,
is page 8.
that is the present FIR.
Present.
That's a relation. Father asking mother not to go to a place.
Yes.
That some relation with somebody. So father, that is the case.
Yes, my lord, your lordship. My lord,
Just I'm
Yes.
recalling. I think I have taken the most of this.
my lord, make
Not to kindly go through the FIR, that page 8.
Eight.
8.
So Bul Rabha injured.
my now, my lord,
Now let us come to page 50.
my page
This is the son of the accused in
accused.
page 8.
Page
Yes.
Father and son, they went to bring their mother. There are 5 accused persons.
What about this affair?
Page number 15, my lord.
Registered?
Yes.
Is there
I am not appearing.
any bail application filed?
Yes, my lord. That is in the additional affidavit. They have been granted bail in the cross FIR. 4 out of the 5 have been
Where is the additional affidavit?
affidavit. It is there in the record. Filed it on Friday.
Okay, that is it.
My lord, my lord,
Just- They've been granted bail by
court below.
Court.
My lord, I just beg my lord's indulgence to para 2 of my additional affidavit, my lord. This is the story, my lord. And thereafter, whatever order calls from a lordship, my lord, I'll be obliged. My lord. And I have annexed the bail order. Also. This is what had happened. May I read it?
Yes.
My lord, that is state that the actual fact is that the wife of the petitioner, namely Bharati Saikia, because of some marital dispute in the month of July 2023, had gone to the house of her mother. On 1/8/2023, she, Bharati Saikia, came to the house of her elder sister, namely Aroti Bora, who is the informant in the instant case and accused number 1 in the cross case. On 2/8/2013, that is the very next day, the petitioner went to the house of Srimati Aroti Bora to bring back his wife, as the house of Srimati Aroti Bora is often infested with unknown men. But Aroti Bora, with the help of his son, Rinku Bora, accused number 2 in the cross case, and other abused the petitioner and sent him back from the courtyard itself. Therefore, this time on 4/8/2023, that is the date when the incident took place, he thought that if he goes with his son, informant in the cross case, also an eyewitness, probably his wife would come seeing the son. Accordingly, on 4/8/2023, the petitioner and his son went to the house of Srimati Aroti Bora to bring back his wife. And when the petitioner called the name of his wife from the courtyard, suddenly Srimati Aroti Bora, along with her son, brother-in-law Pradeep Bora, accused number 4, and some person who are in no way related to the family of the informant or his wife, namely Pul Rabha,
Who is this Aroti Bora?
my wife's elder sister.
Okay, so your wife used to go to Aroti Bora, and Aroti Bora's family is something not
Yes, yes,
accepted
yes.
or activity.
So, brother, and some person who are in no way related to the family of the informant or his
So
wife.
according to you, Aroti Bora hit in your leg by with a dowel.
Yes, and Pul Rabha wanted to was trying to sway the dhow, and Arati Bora took that dhow, and he came out of the house in an inebriated condition and started to assault the petitioner. Arati Bora thereafter bought a
What is
dhow.
the case that is
Lord,
He and his son, unarmed, they went. One person pitted against 6, a mob of 6 persons. Just to save his life, my lord, he took that, and he is also under treatment, my lord.
there refers the subsequent. There refers the
Attending treatment.
who is this lady?
Arati Sekia, my wife.
She was also beaten.
No.
Whose photograph is this?
this Lordship Pul Rabha's photo.
No, Pulpava.
Yes.
What is the case number? Your case number 207.
207.
207. How many people
Three
got
persons,
injured?
3 persons got injured.
One is
Pul Rabha
Bulrava
and
in
another.
his head.
Yes.
And what is who is the lady?
Lady, one Lordship, one
Ring-
Donny Soikia and one Rinku Bora, who happens to be the son of the informant, Aroti Bora.
My photograph also I have annexed, my lord.
We are concerned in respect of Golaghat PS case 207. Any weapon has been placed by the Naga Dam.
Handle is nicely wrapped with some
Thread.
something
Decorative.
decorative.
People even keep it in their living room.
I have my own putti from but I hope that I need to have to use this. Where is your injury?
My lord, my injury, my lord, will kindly see.
Will
It start-
compare the power of two sides.
From page number 25, it starts, my lord, Jorhat Medical College and Hospital.
Page 36.
Page 25, it starts from page
What
25.
is page 36?
Page 36.
Yes.
Page 36. Page 36, the photograph. This is injury on my leg. But even at this moment, I cannot walk properly. My wife is taking care of.
But the allegation that the condition is clearly visible from your eyes and face.
My lord,
Can you see that you are also injured, no doubt about it. See his face and the eyes more particular. Look at his eyes.
Yes.
after treatment,
Look at his eyes. Yes, madam, what you say?
Lordship, otherwise injury report we have not, that is awaited.
Huh?
And he has assaulted the victim on the vital part of the body, that is on head.
307.
all those accused are given the benefit of
This is the accused. The part, this is the accused, page 36.
page 36.
This is the accused.
And the cross case pilot, 4 out of the 5 are on anticipatory bail. my lord. Now they are saying that we will,
Otherwise,
This is not a fit case.
otherwise, he is
It's been
in this world for not near death. Have you seen his face?
Yes.
That one. Consider the material available on the court. Page of it. Also consider that there is couple between the party and the petition has also got secured, and there was cross case where the accused informant the present case has already been granted and been paid. No further no custodial hearing. Or it can tell out FPIP.
I'm sorry, Plumber.
obliged.
That is a fact. You are in a very bad condition.
Yes.
So
Let it be.
Yes, but I was other court matter. Okay.
okay.
But here, the case is by your lord, main accused the person who.
Co-accused is you are the co-accused, you
I am
understand, but
quite sure, but he simply named that we are
not
also involved.
specifically he is also involved. That's why we thought that we because
But when they searched the house, they didn't find anything, man. Nothing was found, man. And here the also main person also, his house also searched, nothing was
page
found.
19.
Yeah.
Isn't it?
Yes, man. Page 19. Of course, that is 439. But your lordship, the important is page 21.
On interrogation, he confessed that he, along with others, namely Motipur
Yes.
Rahman, Riyazat Ali, you
I am, yeah.
are the Riyazat Ali,
Yeah, yes.
then Momtaz Ali,
Yeah.
Teherul 39, Teherul Islam,
Islam.
making fake gold like fake gold
Right.
biscuit,
Counterfeit.
counterfeit currency, Jesus Christ, fake gold, gold, gold.
Yeah.
So,
Yeah,
allegation is specific.
Yes.
No, that is, he stated my lord. This
No, he said
Co-accused.
that
then
during
thereafter, what
trial,
happened?
only on the basis of his statement, without corroboration, you
So
cannot be
he has
convicted.
taken,
We
along
know
with
that.
him, search was made.
But
that-
this is a 430.
That is there. That,
This is a 438.
but-
CTR
search was made, nothing was found.
Which-
That's
on 9th.
ninth one. Today is
If I did early,
Wait a second,
So-
can it be on 6th?
can you do the fifth final?
Oh, it's not.
Fifth final. Be a good final fifth.
Yes, yes.
or no report has come.
No,
No, no,
item
no.
12, Lordship.
12,
My
12.
senior is
12,
asking
okay,
for.
Oh,
What about this
Lordship.
leftover? After some time or what? What was the vehicle?
Swift.
What is the offense?
Offense by the cyber crime.
What will you do with the vehicle?
So we need a report for that.
In the report, what?
Yeah.
Vehicle,
Kindly
in the
give us a short
vehicle,
paper.
report has not come out. Have you,
Not
have you,
come.
have you talked about?
Yes. Yes, sir.
Yeah.
That is,
It is submitted that the report has called for has not. According to that,
on third.
on third product, no, the report as directed by the order date 1/9/2020.
How like? My lord, I'm sorry, my lord. Actually, what happened? My previous some
You express the brief.
yes.
What is the issue?
It's my lord. I filed a petition against the MP order.
Any interim order?
interim order is 18,000, my lord.
Are you paying?
Paying me, lord.
Paying?
No,
not
9,000, 9,000. Totally not full payment.
He is not paying, he is paying only two installments till now, only 15,000 he has paid. This that too against this petition is means the order against the fund by filing the petition by her mother, by his mother. Where this petitioner's husband is very old person now, he is bedridden. He needs medicines. So seeing the conditions,
Who is the petitioner?
There is the son, my lord,
Son of?
son of the one.
one more thing I want to tell you.
What is the award?
What is my lord?
9,000 each, 9,000 against means petitioner and 9,000 against the
Till you find start your file, you are vacating the interim.
interim may not be vacated, man. How will eat, man? How will eat? I'm old mother and father. How will eat?
Same house.
How
campus we are
same house?
living, my lord.
Same house means they are living separately. That's why they is here before the court. On begging,
We are
once
trying to
on begging, once he's not giving, on begging, he now all I was the actually this my husband was the all property owner. Everything was on his name. Everything was on his name. Now, since my husband is
Sorry to say,
bedridden,
I am getting nothing. Who is who? What is?
my submission, man, my submission,
No.
my submission.
Who filed case? Mother, father.
Mother-
What was the claim? What was allowed?
Until unless
I
my
am not getting anything.
Oh.
Therefore, give me 2 minutes. Hemendra Dekka, order is passed against Hemendra Dekka.
Yes.
Now, who is Bhavani Dekka?
It is mother of Hemendra.
Bhavani Dekka is mother of Hemendra Dekka.
Yes,
What do you do, Hemendra?
it is a shop, my lord.
is managing two shop, one cloth stores, which I was holding earlier.
What was the award? Where is the award? What
18,000.
page? Any interim order?
Interim
The
order
interim order is
18,000.
Interim order? Directly
18,000.
I think it was 9,000 each for myself and for my husband.
Is
Who is
there
now
any
bed-
stay?
There is no,
not state, not state.
So what? How we are providing?
I am limited prayer, my lord, decreasing the interim order.
You are not paying.
But yes, I am paying
Okay.
9,000.
Okay. The present application.
My lord, one more my submission. This is a judicial order. He should have made a party to the state. State of Assam is not made a party to that. This is
Why?
judicial order.
Why state of Assam is required?
State of Assam is judicial order. This is judicial order to be.
All judicial order state of Assam is required. It is a 125 procedure.
Yes.
Normally,
The present application is filed exceeding an order dated 12/1/2023 passed in MR case number 61/2022 by the learned judicial magistrate first class Rangya Kamrup, whereby the petitioner was directed to pay an amount of rupees 18,000 to the respondent
No,
mother,
9,000 for her mother and,
respondent mother. Full stop.
no, my lord is
Respondent mother.
mother and father. This for 9,000 each for mother
Mother
and mother and father. 9,000 each
For mother
and
and
father.
father.
There is no
Mentioned, especially mentioned. For mother, 9,000.
For mother and father. Mother and father, that is 9,000. It is submitted by the learned counsel represent the mother that though the order has been passed, however, such order has not been complied and complied with till date. Even this court has also not passed any interim order staying the award. In that view of the matter, it is made clear that petitioner, the respondent mother and father shall be debarred to proceed against the present petition for recovery of the amount as per the file application here.
But actually they are enjoying the money at the property.
Whose property?
The property, their property,
property?
their
Whose
father's
property?
property.
Huh?
Father.
My lord, 15,000
Kill them.
18,000.
Kill them and enjoy the property.
The size for property.
First time listed. How many days?
17 days.
17 days. Who are the respondents? Any private? respondent?
Private respondent.
Okay, notice 6 weeks. Steps 4 pages. Within 5.
Different revision picture.
Delay in delay.
Delay. Lord.
How many days?
250 to 50 days delay.
Notice 6 weeks. Step 4 pages. Ashok Kumar Rathi.
Yes.
Where is Mr. Bora?
Junior, I think.
Okay, just tell me one thing. First of all, we have taken a decision already. We'll allow this. But I have a question. I want from you and Mr. Bora. If the earlier judgment passed by the court by my lord H.K. Sir as that paper is based on a Supreme Court judgment, full lifting or something. What is the ratio of full lifting? Right? That much. Sir. I have some 2-3 queries. Will allow not on the ground you have argued. This is my view. I may be wrong. Because 406 so far relating to freedom, the concept will be according to me a little bit different. So the Punjab High Court view that there must be stipulate, it will be filed where it is stipulated. Where is the question of stipulation on freedom? It's not a contract. That is one question. Other is that in the case of full lifting or something like that, you relied on. Kushal Kumar Gupta. Kushal Kumar, according to me, subject to what your senior or you say, Kushal Kumar Gupta, there is no ratio later. It was decided on the fact. Read the paragraph 7. What is paragraph 7? What happened in Kushal Kumar Gupta? There was a no. There was an application. There was an application. Now that application thought to be quashed that there is no environment. Then it was before session dismissed. Then it went to the High Court. High Court. The apex court also dismissed. Read paragraph 7.
Paragraph 6 also, on the other hand, the learned counsel
This is the submission.
submitted that
This is the submission. We are not concerned with submission. We are concerned with the ratio. Paragraph 7.
paragraph 7.
Read.
In the ultimate analysis, what
In the ultimate analysis, this is the decision. Read it.
in the ultimate analysis, what emerges from the submission of the party is that during the trial, the petitioners will have disproved the complainant case that part of the cause of action arose in Patiala, where the dowry articles were to be returned to the complainant. As it stands, the complainant does indicate that a part of cause of action arose in Patiala, thus attracting the provisions of section 181 subclause 4 CRP. The High Court has quite rightly observed that on the bare perusal of the complaint, the Patiala Court has jurisdiction to entertain the complaint. The decisions cited above the petitioner are not of much help to the petitioner.
Then you read paragraph 6.
On the other hand, the learned counsel for the respondent submitted that the complaint itself contains a categorical statement that the dowry articles were to be returned at Patiala Court, thus extracting the provisions of section 181 subclause.
And then read.
It was also submitted that at the stage of taking cognizance, the magistrate was only required to see whether there was any material in the complaint to proceed against the accused, and the learned magistrate has rightly observed that the documents produced on behalf of the accused would be considered at the time of trial.
Yeah.
Then the ultimate analysis decided.
May I put it this way? This judgment,
Your problem in your case is that there is nothing
absolutely,
to say, nothing to
Yeah.
say in Guwahati.
yeah, absolutely, absolutely right, my lord, on dot. On that particular point, my lord will kindly see. Admitted fact, it's been filed here, cognizance has been taken here, search warrant has been issued from here. If your lordship goes to the complaint,
How
there is nothing to
easy-
return at Guwahati. That at Guwahati is absent.
No, forget about at Guwahati. According to my view, even it is not necessary to return at Guwahati.
My lord.
Okay, we go to that extent for relating to freedom. But the question is, why are you in Guwahati? No statement that or that you made a demand from Guwahati.
My lord, that is not necessary
Okay,
as per
you
three
do
judges
want-
judgment. My lord will kindly see. The three judges judgment to there.
Why? They are
Yeah,
only address.
Yes,
Going
yes,
to
I have
address
given the
because-
address and she has been living here only. My lord will kindly come.
Because
Three
some
judges
environments are
judgment.
required.
Don't do.
That is
My
what
lord
the
will kindly
Supreme
see
Court
two judges, two judgment, my lord. I'll rely on this, my lord will differentiate it,
Okay,
allow
well,
their
let us
petition.
do one thing. Let Mr. Borakam just will rephrase the thing.
Yes, yes.
Huh?
At my lord,
At two.
may I make it at 2:15 or
Yes,
2:30,
yes,
my lord?
2:15,
Because
there is some other method.
there is a witness has been waiting,
Okay,
chief has
okay,
been
okay,
recorded. I
okay.
come and finish
Okay,
it.
you just come, both
yeah.
of you
Yeah.
together come.
Bora will be here at
Okay, what you want?
Very
to add?
interesting point. Very interesting point.
Certain things are in my
Yeah.
mind. I want some. If we say that no environment is required, then it will be difficult
Different.
with all cases.
No, so
Because
far,
whatever I would say. it will
so far
be-
matrimonial dispute, my lord, and so far it's a continuing offense. The interpretation will be different.
Okay, let us see. If you distinguish that no, 403 so far related to the question of freedom will be is to be looked at from a different angle.
179 consequence. Deprivation is consequence.
There is no urgency as such. If we
No,
make,
no, my
if
lord.
we make it CAV also no problem.
No issues at all, man. No issues.
And even my lord will
tried-
go to that
I
extent.
tried like anything.
My lord will kindly go to that extent. That's what I have given a try on the last occasion. Now, my lord, quash it. Tomorrow I send a legal notice to them, return to Guwahati. Again, I can file continuing offense. There is no limitation.
That's because the judgment you have relied on by my lord Justice Sharma says that it's a continue. 40
In the Supreme Court judgment, recent, continuing.
continue. If it is a continuing offense, now there are three categories. First is where offense is committed.
Yeah.
Second is 181
Where misappropriated or
prohibition
yeah.
or where
is asked to be returned,
asked to be returned
And
or
fourth,
accounted for.
accounted for,
Accounted for.
and court will be coming in consequence.
Now stipulation I have reservation so far relating to treatment because there where is from stipulation will come. There may be in a contract, commercial contract that this will
Correct.
be
This will
delivered
not
on
come
such
under
and
that.
such. You have not. There may be some stipulation. Will there be stipulation on the date of marriage that these are the three dons? In the event there is a dispute or so it is to be
Returned.
returned.
Sure.
Stipulation will amount.
Absolutely.
But your petition is also
My
not
lord,
drafted,
I'll try to, my lord.
not drafted.
Fact of the matter is, when there, but there is no abatement.
No, nothing.
Nothing.
In the initial
So,
deposition there,
anyway,
I
your
have
comment in
asked to
the world
return,
is not- that's the
asked to
problem.
return, but not been returned.
You have tried.
I can try, my lord.
Yes.
Everything
But
is
our-
your lordship, my lord.
No, no.
And-
We'll have to pass a return order
Absolutely.
on the basis of law.
Absolutely. And this will be a beautiful judgment, my lord. If your lordship is a continuing offense, and thereafter,
Therefore, we'll hear you again
the-
and make it CAV.
yes, it was judgment of 12. It was a photocopy. Photocopy. Itu আমার copy. Here to our copy.
What? Why further investigation? Because he cannot say we recovered. What investigation? Why? Because it was carrying some cyber crime, no?
No, it was subsequently, after 1 month from his position of his wife, it was not in connection with any offense.
Connection. When matter is fit, it can it should be then it should be okay, treated. You have it treated. Problem. Bora, that's participate. Now, these are academic, huh?
Before the lawsuit starts, I think both big are there, they will may take time. I have item 39, my.
39.
How much time, madam? I presume there's some more time maybe taken by both the.
So you want some adjournment?
If possible, madam, I think, madam, instead of waiting, madam, I could,
But after
any day, madam.
after any interim order?
Yes, yes.
Our thing, trend is always habit of intruding everywhere, either in the politics or in the court.
Court, I do not know, but other parties not been successful.
You lost the right. So he's encouraging also, madam. Sometimes when I like to go somewhere, he also.
That the other part is still going on, man.
Going on.
Still going.
It's a bora, that's the query. Like share. there is no whisper whatsoever about what. No doubt on that.
What about
About any action, anything
in
in
Guwahati?
Guwahati except that I so and so is permanent resident of.
Yeah.
Nothing else. Just to clarify my mind. Yeah. I do not know for how many days I will have here. I should learn something. Otherwise, it is 181.
Yeah.
Some thoughts, you can say some, but otherwise, I express my views that they get clear. Just a view actually. If the view was there, we are not. So let us go to 181.
My lord.
Any offense of criminal misappropriation or this is an exception.
Yes.
This is an exception as we understand. But legislature with its wisdom thought that we should give a special provision so far relating to this
Criminal misappropriation.
criminal any offense of criminal misappropriation or criminal breach of trust may be incurred in or tried by a court. Number one, within whose local jurisdiction the offense. In offenses, in this case, from the pleading offenses committed at all times. One part at
Mumbai.
Maharashtra. Or any part of property which is subject to offense was received or retained. It was at Kolkata. Or was required to be returned or accounted for.
Yes, correct.
By the agency. What do you mean by required to be returned and accounted?
Suppose there is an apartment. Suppose there is a dispute between the two companies for somebody, and there is a apartment or agreement that in case of there is some dispute, you have to return it back to so and so place.
So there is some stipulation is required
Required.
in terms of the Punjab judgment. That has been clarified.
So there has to be something between the parties that the where to disputed property is to be returned or where it's accounted for. Suppose the bank is here and the misappropriation committed somewhere in other bank, but the account has maintained in this account. Then also this court has the Guwahati has the jurisdiction. In case of a bank or this kind of commercial dispute, because the money ultimately accounted for in that particular.
Yes, that we understand.
So first of all, there is no apartment to that effect that any kind of offense being committed is one. He resided here, no doubt about it.
Now suppose and again what is freedom?
Even in case of a Sridhan also, my argument is that Sridhan also is her property entrusted to somebody, and it has to be returned to her. No doubt about it. It has to return. She has the entitled, but she has to avoid. There is no presumption available as per our High Court judgment that it has to be returned to a parental house.
No,
Unless-
not parent.
Even if she is silent about it, even then, there cannot be any presumption to this effect. Our High Court, Justice Mir Afzal Ali's judgment, that there is no presumption is available that it has to be returned. If there is no apartment even, that it has to be returned to the parental where she is residing. That presumption is also not available.
Okay. So therefore, so far relating to Sridhan, there cannot be any stipulation.
Stipulation
regarding that it should be returned or accounted for.
Yes.
So to that extent, I am not agreeing with the view of the Punjab that there is needs a stipulation so in respect of Sridhan also. How a stipulation can be there because these are the disputes post marriage.
Yes, of course.
Post marriage. The Sridhans are given at the time of marriage, give by the family members or something, it is not as such a dowry. It's a Sridhan. Now, can there be stipulation in the context of a Hindu marriage that in case of dispute it will be returned on Thursday? If that stipulation is there, then itself the marriage, from the starting point, that marriage is gone. This is that thought. So therefore, now stipulation I am not agreeing. Now whatever you have stated is that there must be statement, and there is no presumption that where is she is to be returned there.
Even in the parental house.
Even in the parental, there cannot be presumption. Now that is in the case of, what was the case? My lord, Miss Alpha's judgment,
Mir Hafez Ali's judgment, my lord.
yes, is what was the name of the judgment? That is
Kuljit Singh Sethi.
Kuljit Singh Sethi was based on which judge? Let us see where is that paragraph.
Paragraph is, my lord, 16.
Paragraph 6.
The question whether there is any stipulation to return the property at the parental home of the wife is a question of fact and has to be decided on the basis of the evidence of and the facts and circumstances of each case. The present case, there is no material on record to show that the properties were to be returned to the wife at her parental home at Jorhat. There is not even an advertisement in the complaint to that effect. Therefore, on factual metrics of the decision of this court that Balakrishnan Sadhani's case has no application in the instant case, because in that case, Balakrishna, there is a specific advertisement where it has to be returned. On the facts of the case was decided the properties has to be returned at the place where the wife was residing, and no ratio was laid down. This is important. No ratio was laid down that there shall always be a presumption that property shall be returned to the wife at the place of her residence or parental. So that presumption is not automatic unless and until there is an advertisement to defend. So there is no material on advertisement on the complaint.
There in this case, specific statements are there that it was demanded in all flat, but they refused and they said that some portion has already been sold. That
That's the
statement,
allegation,
that statement
yes.
is.
So now even now I think one thing is very important. One judgment will decide everything. Just one line. My case is that what I like to project before your lordship. Even in case of 498A, there is no blanket presumption.
No black paper. Shelter is a
Even then, that the consequence that it is the judgment of the Rupali, that the consequence ensued, that also has to be averted. It's not that because of the 498A, he has taken shelter into different places. All the places of have the jurisdiction. That's not the question. It will depend on the advertisement and the facts of the case. It's not blanket protection if given to the wife that just because of the cruelty, she has taken shelter in some place. If there is no advertisement to the effect, factual advertisement. Actually, there is nothing on that. Why she has gone into that place? Suppose there is a cruelty, no doubt. Cruelty is a continuing offense. But if there is she is silent about it, wife is silent.
No, that is because there is a specific jurisdiction.
Yes.
An exception is carved out
Yes.
in Rupali in certain background.
Yes.
So
So that background, yes,
fact
background,
should be
that-
stated in the
Either in
complaint.
the offense,
or it cannot be automatic.
it
cannot
cannot
be
be automatic. That is what I'm
And that
saying.
is there is no quarrel on that.
So
Because otherwise from where jurisdiction will come? There must be a statement. Jurisdiction cannot
So-
be presumed.
even in a 491, had it been so my learned friend's contention may be that because of the consequence ensued, she has taken shelter in Guwahati.
But there is, a statement is required.
That is my submission is that, yes, if he has
That is
stated
my view also. A few minutes back, I told him.
that if that would have been there, that because of the consequence ensued, I have been ill-treated in Mumbai, then I'm in my parental place, so I could not stay in my parental.
Nothing, why she has come to Guwahati.
Yes. So it is not an automatic presumption.
There is nothing, Mr.
So, so that, my lordship, kindly see the Rupali Devi judgment. One line I'll just place it before you. My contention is very specific, and that has been in the Rupali's case, paragraph 16.
Just give me a minute. But yes, paragraph
16. So it's not in automatic. In case of 498A also. We therefore hold that the courts at the place where the wife takes shelter after leaving or driven away from the matrimonial home on account of acts of cruelty, my lord, committed by the husband or a relative would depend, would depend on the factual situation.
yes,
Also have the jurisdiction to. So factual situation has to be averted. It cannot be automatic just because that it's a 498A. So I have taken shelter in the different places. Tomorrow I'll take a shelter in the Andaman and Nicobar. Tomorrow I'll go to the Fotia. It's not that. She has to avert why she has been taken shelter in Andaman or in the other places. Then only the jurisdiction is not automatic in case of even the 498A also. But yes, she has, it was a continuing offense. So if she averts that, then that particular place has the jurisdiction. So that is one part. So factually they have to avert it. Next part is that this is a special case, my lord. This is a case of 498A is a cruelty. But here
here,
is a criminal breach of trust. Both are
498
distinguished.
cognizance is not taken.
Yes.
Even dowry demand was specifically made, no cognizance was taken, and he is not agreed.
So, and that was
You are
not,
not agreed.
that has not been challenged. That order has not.
Specific, that demanded the dowry.
Even then,
There is a distinction between
I will answer.
freedom and dowry.
I will
They are
answer to that.
specific that thereafter they say that it is less, so bring more. Accordingly, money was transferred. I purchased all this, but
and even then,
cognizance is not taken.
so even
not
let us
I'll try to.
no, even then,
Hmm.
minor, even then let us assume it that the cognizance has been taken in 498A also. Even then
Then that is it.
then also the Rupali judgment covers that even then you have to avert that some offense was committed in Guwahati.
Or
Or
that
the
due to
consequence.
this cruelty,
Yes,
will have to
or the
settle at Guwahati.
Guwahati
instead.
or the consequence is ensued. That's because in the Guwahati and the Guwahati there is some demand or the I from the now or there is a apartment that now I have settled in Guwahati. So
And
it
I
return
asked,
back.
asked
Ask
for
of return it. There's to that effect some at least. So factually it has been. So even the Rupali
That-
Supreme Court says that you cannot have the. So next point is my point is that Lordship
That
here
is what has been written in this judgment. But still, I thought I should.
my
I will try to.
the next part is my argument is that this is a case of a 498 It's not a case of a criminal breach of trust. Both has to be distinguished because it's a 498 is a cruelty and it is a continuing offense, mental or the physical, whatever. But the criminal breach of trust is a different. That is,
But one thing, the judgment you relied on by my Lord Justice H.K. Sharma,
yes,
as then he was, lays down specifically that
That is-
406 is
it's
a
a
continuing
continuing
offense.
offense. Continuing offense just because there is an argument that there is a delay. Because it has to be filed within a period of 3 years or 2 years, whatever. So that was the continuing offense. So after 5 years also, so it will continue. That can be filed in anywhere. So, but why 181 has been carved with? So we have to read 171 vis-a-vis 181 subsection 4. we cannot segregate 181 subsection
No,
4.
we cannot. We'll
Yes.
have to reconcile.
Yes, both.
Both,
Both.
reconcile.
Reconcile both. So 171, read with 179, read with 181 subsection 4, we have to reconcile every time. If it comes within that parameters of all the three ingredients of every section, then yes, the Guwahati may have the jurisdiction. But otherwise, my case is that because she was absolutely silent, why she has resided, is it a consequence of the offense or is it because of the cruelty meted out to her? She has no option but to leave it in Guwahati.
Or
To that
that,
effect.
or that she demanded from Guwahati.
Yes, no,
or
nothing. No avertment, not by him, not by the other 202, the witnesses examined. They have also stated. Rather, everybody stated it is Calcutta. Even then there is a statement, categorical statement of the father that after the cruelty meted out to her, she came because of the cruelty, he has to take shelter in Kolkata, not in Guwahati. So that is the end point.
there is no sequence of events.
Then no
leading
sequence.
her to
Yes. So that
come to Guwahati.
so my case, even in a 498A, I'm repeating, my lord, the paragraph
So
16.
condition precedent is that the section 16 should fulfill. That is the condition precedent to have a jurisdiction even in the case of 498.
498. There is no.
That fact should remain.
Yes,
And
that fact.
fact is disclosed from the environment.
Yes.
This is it.
Either in the apartment or in the
Or
FIR
in the
or somewhere.
application.
In case of there's a little bit of there. In case of an FIR, there may be some apartment in the circuit or somewhere. But that apartment should be there.
That
That
this
is-
situation happened.
That then because of this is why the very 16, the paragraph 16 is very clear that on the factual situation, it's not a blanket. Otherwise, our High Court says that there is no presumption of law in that fact. So presumption is available that because even in the matrimonial house doesn't have the presumption that the moment she has taken shelter, even in that case also she has to avert.
That is where I have a little bit of doubt, but it is I think
That point has been made.
here
Sir,
I have a
yeah.
so far because in my mind was the return and 406 in the context of return will be a little bit different. That was my mind, but presumption, my lord, that I have not got told. That is settled that there cannot be.
Yes, that,
Until and unless there is an error.
Yeah.
Or there cannot be automatic presumption.
no,
Just
even
think,
in that
I had also this view. Let me be frank. I had that okay. It says here, there is a fact that is disclosed that is now a resident of Guwahati.
and the 181
Now,
and
if
181 Lordship, I'm just 181, every word is that where offense committed, where she resides not, where offense been partly committed. The word is offense.
But these are alternate.
So one
Not that it should be, but these are all these are situations. Situation one, situation. Suppose one of the situation is satisfied. Offense is committed at Kolkata. Second is also at Kolkata. However,
the consequence.
third is there is a stipulation that it will be returned at one.
Yes.
Then also
Yes,
406 will
Yes,
come.
yes.
So it's not that all three should be.
Yes.
Either any of one should be. I initially what inside my mind was that it's a return 406. It's her property. If it is prima facie case of misappropriation is made out, it is the duty of the person upon whom the entrustment is made is to return.
Yes.
If that be so, it will mean that it should be returned to the person and to the person where he is residing.
Resides. But that presumption is not automatic. There's no
That is
presumption.
the law.
That is
As
the
on
law.
that.
As on that, presumption is not law.
My
Unless and
view
until.
was against that law.
Yes.
But that is the binding precedent upon.
So that presumption is not automatic. Even the Supreme Court also said that even case of the 498A, forget about the 406, that that the presumption is not automatic. The factually, there has to be something, because presumption always has to be based on fact. There cannot be any presumption on vacuum.
Jurisdiction always based on a fact.
Fact. So even the presumption, if we take the presumption also, presumption has to be based on certain facts. There cannot be a presumption on another presumption. That she has been fled away from this place
Yes,
to this
you
place.
take
Yeah.
it, Mr.
With
Because
regard to the
can I
law,
take it?
my-
Because my division means there is one matter is going on. Just
Yeah.
for 5 minutes,
now,
That this is for only to
yes,
clarify
academic
certain-
purpose, my lord, whatever.
I'll
it
come
is,
back,
my
my
lord.
lord, within 5 minutes. Just
This whole chapter with regard to jurisdiction, my lord, kindly see. My lord, was this one, 177, 181, 4. Ordinary place of inquiry and trial, 171. 179 talks about, it's an distinct independent sections of law of the code. That means thereby these are distinct provision that has been made to meet certain exigencies in certain situations with regard to cause of action, the jurisdiction. So my lord will kindly see 179 is an independent distinct of provision that has been made. What it says, my lord, last lines, my lord, last line, within whose local jurisdiction such things has happened, has been done, or such consequence has ensured. That is very important, sir. I'm pointing out that particular line. And coming to 181, that is another provision, is a distinct provision. Place of trial in case of certain offenses. One, any offenses of being a thug or murder committed by a thug, of dacoity or dacoity with murder, or belonging to a gang of dacoits, or of escaping from custody, may be inquired into or tried by a court within whose local jurisdiction the offense was committed or the accused is found. Now, this is with regard to dacoity and thug and all such things. Any offense of kidnapping or abduction of a person may be inquired into or tried by a court within whose local jurisdiction the person was kidnapped or abducted, or was conveyed or concealed or detained. Now, with regard to 3, any offense of theft, extortion, or robbery may be inquired into or tried by a court within whose local jurisdiction the offense was committed, or the stolen property which is the subject of the offense was possessed by any person committing it, or by any person who received or retained such property, knowing or having reasons to believe to be stolen property. Now, the 4th situation with regard to misappropriation. Now, my lord, misappropriation 403 is also a misappropriation, my lord, under IPC offense. 405 is the criminal breach of trust. Both are included in this offense. Any offense of criminal misappropriation or criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed. So, entrustment, my lord, and misappropriation. That entrustment is Bombay and Calcutta, and misappropriation is Calcutta. That has been averted in the complaint.
Okay.
Yes. Whose local jurisdiction the offense was committed, or any part of the property which is the subject of the offense was received or retained.
That is a
Yes, that is Calcutta.
specific step.
Yes, that is there. Or was required to be returned or accounted for by the accused person. Return the place wherein in the complaint it is absolutely silent, admitted, with regard to the fact that it is to be returned to Guwahati. But the word is there. I have repeated requests. At the time of leaving the matrimonial, she wants to take it. She has not been allowed. So she came to Guwahati. We go on facts. If the facts has been looked into totality, she, having no other recourse, she came and took shelter at Guwahati. She demanded from Guwahati to be returned. It's not
Where
that
is that ever happened?
no, it is there. I'll come to the complaint. It is not there that to be returned at Guwahati, but there is avertment to be returned. That is there. I'll try to project
No,
this one.
Here is an advertisement saying that these are the first, these properties were given, then again 5 lakhs
Yeah.
transferred to
Yes,
account, withdrew it,
Yeah.
given, and from my account also given, but subsequently started ill-treating. So I came
Yeah.
back to my family house, matrimonial house
Huh.
at Kolkata, and demanded the return of those amount.
Not at Kolkata, but at
No, no.
Guwahati.
No.
No.
Come
At
to the-
Guwahati, my lord.
Come
Kindly
to-
come.
I have specifically marked
No,
it.
no. Yeah.
If Guwahati was there,
No, accused person did not stop on 10-9. My lord, that is paragraph 11, kindly see. That is a page 19 of the quashing petition. Complainant made effort to save the marriage even after giving repeated assurance by the accused persons. The mental query towards the complaint by the accused person did
Paragraph?
not stop. 10. On 10-9, she had been subject to physical assault by the accused number 2.
Page,
Criminal petition, my lord, page 19, my lord.
19.
19. Then if your lordship come to page 10, that will be clear. 20.
Hmm.
Yes. On 10-9,
No, no,
2018,
it's 16.
she had
Starts at page 16.
here a copy that has been furnished to me. That is
Annexure 1, isn't it?
uh,
Mr. Bora?
yes, the complaint.
Page 20, paragraph 10,
Page 16 it starts, my lord.
page 16. sir.
Yeah, the advertment I am making in, my lord, that is advertment number 10 in the complaint. I am not going to the first lines, my lord. At page 20, my lord, you will kindly see the next page. Residents of the complainant made effort to save the marriage, but even after giving repeated assurance by the accused person, the mental cruelty towards the complainant by the accused person did not stop. On 10-9-2018, she has been subject to physical assault by the accused number 2 and accused number 3 in presence of accused number 1. And the accused number was silent spectator to the whole episode and didn't even bother to stop the physical assault on the complainant by the accused number 2 and accused number 3. 11. The complaint states that on 10-9-2018, she came out of the matrimonial house, leaving behind her street-hand, as mentioned in the lease annex so-and-so, as the same has been refused to give her by accused number 1 and accused number 2 and accused number 3. Now,
Yes.
yes, at that refuse, then she came in, make a demand, return my student.
Where is that?
That I am coming to it, my lord. That I am coming specifically to it, my. Paragraph 12, my lord, will kindly
Yeah.
see. The pieces say in the month of October, November, and December 2018, the complainant and her parents made endeavor to pursue the accused to return her student
Yes.
given at the time of marriage by her parents. Friends, guests, so-and-so, it is not been returned. Then again, my lord, a specific date, paragraph 13, that the complainant states that on 13-2-2019, efforts has been made by the complainant and her family through their common friends, requesting the accused to return her student. It is not in Guwahati, my lord,
Hmm.
but it has been there to return the student. That means whether this honorable court
So
will,
therefore,
that is the disputed question,
that
that
was
to
the-
at Guwahati or in Kolkata.
But where is your advertisement?
No, I'll come to that, my lord. Whether advertisement is
Any
necessary.
Word Guwahati, how you have come,
Yes, that whether that is necessary.
except
My lord,
in your address.
no, absolutely, my lord. I'll try to satisfy this honorable court. To my respectful submission is that advertisement is not necessary. That return at Guwahati. Because they know I am in Guwahati. I am calling up, return my freedom.
But the judgment of my lord just.
I'll try to satisfy. I'll try to satisfy.
Until and unless
Yes, I'll try to
I,
satisfy.
I disagree with and refer, then I'll have to refer it to a larger bench.
That's what I am saying, my lord. My lord, I will come to the judgments also. Here, it's not been there. I admit that. Return to Guwahati. But does this word is required in the complaint or in the initial deposition? Because in the initial, return my property.
According to me, it was not required because he'll have to return where she is.
Absolutely.
But the judgment says that.
No, the
there cannot
judgment can be
anything
differentiated, my lord. On the factual part, it is clear now. Now, it is not
else.
that
Actual, there is no whisper
No,
about Guwahati, how you have
Guwahati
come to
and
Guwahati,
whether
what was the
court,
reason, whether any demand from Guwahati, nothing is there.
so my lord, specific words are not there, but it is as such that
We'll have
that
to
return has to be
presume
at
that,
Guwahati.
the demand was, when demand was made, in the
It is
meantime,
from Guwahati.
you are in Guwahati.
Yes,
Where is there?
my lord.
We'll have to presume it.
No,
Can a fact be presumed?
no, my lord. Facts can be presumed, my lord, on the statement that has been made. What are the statement that has been made in the complaint in the first paragraph itself? That she has been so-and-so, so-and-so resident. Now
When?
he's been staying out here. That has been the statement that has been made, my lord. Now, my lord will kindly, my lord, give me that opportunity with regard to Rupali Devi's case. Admittedly, this is a three-judge judgment. Admittedly, the dispute arising out of matrimonial dispute. Admittedly, in these judgments, 177, 178, 179 has been discussed. Now, with regard to a factual metric of a 498A. Now, 179 has been appreciated in this case. Paragraph 8, my lord, will tell it. Paragraph 8.
Rupali Devi.
Yes. One question was framed, my lord. That question is very important. Whether a woman forced to leave her matrimonial home on account of acts and conduct that constitute cruelty can initiate and assess legal process within the jurisdiction of the court where she is forced to take shelter with the parents or other family members. This is the precise question that arises for determination in this group of appeal.
Okay, stop for a moment.
Huh.
Suppose a lady files a 498 application, marriage is in
Kerala,
say Kerala, she stayed with Kerala, she files an application
from
at
Guwahati.
Guwahati. But there is no averment that that due to cruelty, she is to leave. Where is local record channel? Where is the question? Where is the just now you have read?
First, my lord, starting with the question that was framed, whether a woman forced to leave
Where-
her
where
matrimonial home
paragraph five.
on account of acts and
Paragraph
conduct.
5. Okay.
Huh.
Okay.
That
Paragraph
was a
five.
question framed in the first.
So that statement must be there. That in this background, I have filed this petition here.
No, my lord,
If
that
that is
statement,
not there, can there
that,
be a,
that statement is.
just a minute. Suppose that statement is not there. Let us
Huh.
take a 498 application.
Huh.
That statement is not there.
Huh.
And she files it. Will there be a presumption that she was compelled or due to the cruelty she was residing and therefore she was compelled to file the case beyond the jurisdiction of the actual court?
Now, as
And
for this judgment,
there-
I'll take your lordship to the judgment, the operative portion, my lord. But here the distinguishing factor is this.
Then
In paragraph 11,
Hmm.
I have stated 10/9/2018, she came out of the matrimonial living behind her student has been refused,
to where?
my lord,
To where?
to Guwahati, my lord. It's been
No.
filed in Guwahati, my lord. That word is not there, my lord. But the consequence itself that her address is at Guwahati. And she has shown her address as Guwahati. That is inferred with regard to this, my lord. I'll try to take this honorable to paragraph 8, kindly see, after framing of the order, my lord, this question. Paragraph 8 is very important.
Paragraph 8
Eight.
of
Judgment,
the
Rupali, my lord.
Rupali.
Yes. May I read it, my lord?
Yes.
Section 178 creates an exception to the ordinary rule engrafted in section 177 by permitting the courts in another local area where the offense is partly committed to take cognizance. Also, if the offense committed in one local area continues in another local area, the court in the latter place would be competent to take cognizance of the matter. Under section 179, if by reasons of consequence emanating from a criminal act, an offense is occasioned in another jurisdiction, the court in that jurisdiction would also be competent to take cognizance. Thus, if an offense is committed partly in one place and partly in another, or if the offense is a continuing offense, or where does consequence of a criminal act result in an offense being committed at another place, the exception to the ordinary rule would be attracted, and the court within whose jurisdiction the criminal act is committed will cease to have exclusive jurisdiction to try the offense.
Then why section 181 was required?
That I will try. That
Why
is
that
under one
incorporation
chapter, my
of
lord.
section
Yes, that is misappropriation and criminal breach of trust.
Not
now-
only 181
Four.
A 1, 2, 3, 4.
Robbery,
Why
extortion.
certain offenses, there is special provision?
Yes.
Why legislature intended to give a special provision for some special offense?
Yes, that I will try to. But first, I will try to satisfy from this that 179, 181, these are independent, distinct procedural code, my lord, that has been provided, sections of law. If at all, if a case is under 179, consequence follows, then 181 is just my lord, another provision. It's not that a case with regard to 179 is made out, so 181 is been not there, avertment is not there, consequence follows, then 179 is sufficient in a criminal matter. So far, matrimonial dispute is concerned. Because this has been a judgment with regard to matrimonial dispute. Consequence with regard to, I treated a girl very badly, abused her. She goes to her house in Mumbai. She files a
Understand
case.
That
Consequence.
that that fact should be before the court. Yes, this lady is helpless. She has stated, I might not have
He
the
has stated
jurisdiction.
that I, at the time of living on 11/9, want to come with my, they refused to give me. So I have filed, her address is at Guwahati. That statement is not that,
So
that
we'll have to, the
appreciate
court,
the whole.
the court will have to insert things
No, no, no,
between-
my lord. It's not
between the-
required, my lord.
between the gaps.
Inference, my lord. In
That will
on
be-
facts,
That
facts.
will be a dangerous thing to
No, my lord,
pronounce.
it will not be dangerous and there are precedents. I'll try to satisfy. Now, from paragraph 80, what it says, my lord, consequential follow if it's a continuing offense, then Guwahati will have the jurisdiction. Now, I take this honorable court to paragraph 9. At this stage, it may also be useful to take note of what can be understood by continuing offense. This is very important.
Paragraph
9.
of Rupali.
Rupali. The issue is no longer res integra having been answered by this court in state of Bihar versus so and so, maybe notice so and so. This is the paragraph, my lord, I am reading it. A continuing offense is one which is susceptible to of continuance and is distinguishable from the one which is committed once and for all. It is one of those offenses which arises out of a failure to obey or comply with a rule or its requirement and which involves a penalty, the liability for which continues until the rule or its requirement is obeyed or complied with. On every occasion that such disobedience or non-compliance occurs and reoccurs, there is the offense committed. The distinction between two kinds of offenses is between an act or omission, which constitutes an offense once, and for all, an act or omission which continues, and therefore constitutes a fresh offense every time or occasion on which it continues. In the case of continuing offense, there is thus the ingredients of continuance of the offense which is absent in the case of an offense which takes place when an act or omission is committed once and for all. So 498A has been taken as continuing offense, my lord. 406 itself is a continuing offense, my lord. And now I come to the last part, my lord, paragraph 15. The Protection of Women and Domestic Violence Act as the object behind its enactment would indicate is to provide a civil remedy to victims of domestic violence as against remedy in criminal law, which is what is provided under 498 of the Indian Penal Code. The definition of domestic violence in the Protection of Women and Domestic Violence Act 2005 contemplates harm or injuries that endanger life, health, safety, life, limb, or well-being, whether mental or physical, as well as emotional abuse. The said definition would certainly, for reasons stated above, have a close connection with explanation A and B to section 498A of the Penal Code, which defines cruelty. The provision contained in 498A of the Penal Code undoubtedly involves both mental as well as physical well-being of the wife. Even the silence of the wife may have an underlying element of an emotional distress and mental agony. Her sufferings at the parental home, though may be directly attributable to commission of acts of cruelty by the husband at the matrimonial home, would undoubtedly be the consequence of the acts committed at the matrimonial home. Such consequence by itself would amount to distinct offense committed at the parental home where she has taken shelter. The adverse effect on the mental health in the parental home, though on account of the act committed in the matrimonial home, would, in our considered view, amount to commission of cruelty within the meaning of section 498 of the parental home. This line is very important next. The consequence of the cruelty committed at the matrimonial home resulted in repeated offense being committed at the parental home. This is the kind of offense contemplated under section 179 CRPC, which will squarely be applicable to the present case as an answer to the question. So where there is a cruelty or otherwise deprivation of the woman from her stridhan, wherever she goes and files it, my lord, at any place in India, that is not the question. Parent, it should be parents. No, wherever she goes and files it, will have and where she has been deprived of, the consequence ensured that place, and he had to return.
We agree. But where is that fact
My lord,
before-
I'll come, my lord. Another
Agree.
judgment, my lord. This is
During the
Rupal.
fact,
Yes, my learned colleague is appreciating section, paragraph 16 in this. We therefore hold that the court at the place where the wife takes shelter after leaving or driven away from the matrimonial home on account of act of cruelty committed by husband or his relative would depend on factual situation. Also have the jurisdiction to enter a complaint alleging commission of offense under 498A. That lines are in my favor, my lord. Why?
Yeah.
Because she has been deprived of her freedom, refused to be given, so she came to Guwahati and filed
when
it
is
here.
that Sushi came to Guwahati? Give me that what she shows. Therefore, she came to Guwahati
My lord,
and taken a shelter. Right now, dismissing this.
my lord, whether that is
That is
necessary.
not there.
Yes,
That
that
is
may
the
not,
difficulty.
that
All
may not be there.
arguments, your argument accepted, that averment is
My
not
lord,
there.
that
Therefore,
whether now the question
please
comes in,
better
my lord.
extend this bit.
Why my lord, can you give me that time, my lord? I'll try to satisfy, my lord. There is another judgment there, Kotak, Sanjay Jalan, my lord. Very important. Paragraph 32, my lord. And our High Court judgments here, Sharma, my lord. This avertment are not necessary. The complaint has been filed at Guwahati. That means she has been at Guwahati, resident of Guwahati, and she is asking for at Guwahati. That avertment is not required when a criminal distinct offense has been made out. The question out here is whether an offense has been made out. That's the primary question. Yes. And whether the court has the jurisdiction or not, because she has been filed here. Consequence is here. Paragraph 32, my. Prima facie, therefore, the offense of criminal breach of trust surfaces from the complaint as well as initial deposition. Under subsection 4,
For 33.
32,
Oh, yeah.
32, yes. Under subsection 4 of the section 181(4), an offense of criminal breach of trust may be inquired into a tried by court within whose local jurisdiction the offense was committed, or any part of the property whose subject matter of the offense is received or retained or was required to be returned or accounted for by accused person. Under the scheme outlined in chapter 3 of the criminal procedure, while an offense is ordinary to
Before 22nd, second half, I may not be there. So only 3 days, this is not.
Come for judgment.
Yes, it's up.
Okay.
We'll try. We have already declared the order. But to have getting concluded judgment.
This case, we have filed a affidavit, my lord, bringing that part, my lord.
What was this? What was
This is the, that the, my lord, the absolutely, my lord, the case FIR was filed under the 120B 406-409, my lord, 420 at Chirag.
for that case?
Yes, then the magistrate has taken cognizance of the PC Act, my lord. Thereafter, the charge sheet also PC Act. Then he directed for the further investigation, re-investigation rather.
Now what should be the order? Where she is not having no jurisdiction.
Absolutely no
That,
jurisdiction.
that part will be set aside. That part will be set
It's
aside.
up to the state how they proceed with that, with the FIR.
What about
FIR will remain.
FIR will remain.
With FIR will
And
remain.
investigation.
Investigation will go because there is a direction of the press investigation.
Press investigation will go, but the original investigation where charge sheet is filed, so far relating to 120B and all, what will happen to those parts?
That they can continue with that further investigation date and thereafter they can file the charge sheet before
Now
the
suppose, admittedly there is no truth
well,
that
the cognizance is itself is part.
cognizance is gone.
So
The direction
Only-
of
only-
re-investigation or what investigation is gone.
gone. So only remind the past
Direction of
investigation.
registration of
That's gone.
PC is gone.
Gone. So
Only remains is the original FIR
original FIR and the
registered
original
under-
investigation.
investigation.
Only that part.
And on that part,
Then the further investigation can be carried out by the government.
It's up to them.
Up to them, on the basis of the further investigation, they can add PC Act, no bar. Thereafter adding the PC Act, if there is material,
Then
they can submit the FIR in the
in the
final,
special judge-
special justice. Simple as.
ACL to CAV. Any stay order in this case?
Madam,
Any stay order in this case?
state order.
Third is part with for further hearing. How many CAV will dictate but not make it CAV? Third in part, please for further hearing on 9th of October. Any note?
There is a small note. There's two judgment is already.
But this will have to circulate this. That's why I want to write properly. This is not accepted. They cannot do like it.
This is my note.
Huh?
This is my note.
No, I know that. But to write this judgment, we will have to circulate the judgment among the judicial. This is absolutely without it. This just cannot. We take it it's separate from. Keep it. That's why I have kept part. In
And
fact,
the other two judgment I have given the further investigation he can't, PC Act he can't, even the cognizance he can't,
it's special,
everything.
everything, all procedure.
How like?
I'm appearing on behalf of the respondent number 2.
Yes, tell us.
Last occasion, your lordship directed to study the case that because
Status report, madam.
affidavit.
Is passing.
yes,
There is no stay.
no, they-
Then if no stay, whether circuit file or trial is over, he is also not able.
Give us some time.
Kindly see the order in the 24 days. The learned additional copy of the submission may be granted. Some further time obtained the necessary instruction as in terms of order dated 24 / 20. Prayer is allowed. Please.
that
Sir,
may be
request
fixed
given.
department.
Huh?
He- Without any protection, also that may be fixed. We will prepare the case.
Is your client calling you?
From distant place, always.
17th of February. In between vacations. Sir.
In this case, my lord, I have submitted my lord affidavit in opposition.
What is the case?
It is the quashing of the fire.
Oh, that case.
That case, the past of it.
Be happy. Who are your wife or your
Wife and children, child, my lord, son.
have puja nicely with your wife.
Yes.
Wife is now with you.
Yes, sir. Yes.
She is back from him.
Yes.
And now both are together against him.
Yes. Yes.
Huh?
Yes. So,
And according to him, he saved your wife from your torture.
lost it. Yes.
Now see the man is facing an interim order.
Lost it. Charge it. He has not telling my lord charge it, my lord, only FIR. My apartment is there, lordship. No, no, my
No,
lord.
such thing is not required to be challenged. What is the recent judgment?
That's it.
Even if during pendency charge sheet is filed, there is no problem. Charge sheet can be satisfied. Where is the judgment?
No, no, not before it was already earlier charge sheeted.
Lordship, my pleadings is
But
there,
subsequently he filed this petition.
and
not
all
challenge the
lordship,
charge sheet,
and
my lord.
then subsequently also lordship.
Why are you so angry with him?
No, no, I am not
I
angry,
don't
my lord,
understand,
because
lordship,
he
I
is my lord,
understand.
Why are you so angry with him?
It's
I'm not
very
angry, my lord,
astonishing,
only-
my lord.
Don't be angry. He comforted your wife for some time. when you tortured her?
No, my lord, it is false allegation, my lord. She also filed another case, my lord.
Because of
Second,
Why
I
then she left with him?
lordship. Because
My
of who?
child, at least, my lord, my son was, my lord, kidnapped, my lord. Adultery is there, my lord.
And in that case,
No, not kidnapped. Your child went with his mother,
yes,
not with him.
But I am natural guardian, my lord, and he was alleging there, my lord. Then she, my lord,
Mother took her children with him, and he has accepted that. He has not said that don't bring the child.
I am father.
Subsequently, she came back to you
lordship.
because she might have worse experience than what she was having with you,
Yes, but
isn't it?
maybe,
So
my
she thought that better to be with you.
Yes.
And settle it between you. Please,
Already
this matter
requested by
after.
land.
at least smaller crime is there, my lord.
No
Adultery,
question of
my
any
lord,
crime,
my
lord,
child
my land and
kidnapped.
friend. Several lordship any fixed date subject to the before
Deep
puja
level.
or after.
Keep level.
The prayer of the Learned Council put a restaurant number 2. Restaurant number 2 apply. Who applied? Who want adjournment? You want adjournment?
No, petitioner.
Petitioner. Okay. The prayer of the Learned Council put a petitioner matter says adjourned and be listed. Listed when?
After puja.
After the interim order passed. After
Interim.
puja vacation exit passed.
Lord.
That police officer?
Yes.
Okay, after enjoy the puja. You are having a stay?
No, it's but the matter is fixed around 20 seconds. Earlier it was fixed on 10.
I can take a time.
It's still
Please this matter or 20 seconds, this 20 seconds. Not possible. So many judgments.
otherwise, Lord, here, the case for
You
duty on,
know I'm not happy with you.
but otherwise, Lord, it is a very clear cut case. But the case, Lord, mainly, my Lord, on law point, that whether outage setback and negative obstacle to those next of law is very clear. When dispute at the
Whether it is a case of official duty, that's just a question to get. What is the next date fixed for?
here, my Lord, taken
For what?
for taken because on the last
Take-
my Lord, I
Take
made
an adjournment till the release this matter after.
but fix a date.
Give it.
All right.
What there is not there. Yes. Yes, what is the case?
Conviction is 6 months, fine of rupees 1,000 under section 490.
What did you do?
Pending disposal on myself.
What did you do? 374,
No, my 498.
498. What is the statement of the lady?
But the matter is already amicably settled.
File an application.
Yes, I have filed.
Huh?
I have filed. And
Where
the
is that?
lady, my lord, she married to another person.
Where is that?
Have the
Where is that amicably settled?
Lord, I have filed the additional affidavit. Sir.
There is no additional affidavit. Is she a party in this proceeding? There is no additional affidavit.
Her name is not shown.
Huh?
It's not a party here. Her name is not shown in the
Yes.
case.
Is she a party? You'll have to come and say
Yes.
that yes, I have done this.
He is respondent number 1.
Represented by
My lord, so we have not.
Huh?
Respect to the PIC respected.
Subrojyoti
Let
Bhuya.
them appear,
Name shown.
the name
Name
will be
is-
shown in the corpus. in the
Where
name.
is the additional affidavit?
Lord, I filed it on past 1020.
20.
Yes.
So you have
And the matter is 2008. And I have the original marriage certificate and one MOU, which was executed before the sub. I put the
second marriage.
second marriage certificate is there, my lord, and my lord, one MOU was executed in the parties, my lord, for the sub. This I have the original.
But you have to say na,
Yes,
that yes.
let them appear.
Are you still having any contact with your ex-wife?
No, no.
Have a
My lord,
contact
the
for
partner,
the
my
last
lord,
time.
the petitioner is hailing from my lord. Now he is living in, and he is from Bongaigaon. And cause of action was at Bongaigaon.
But problem is that two courts convicted you. And we are in a revisional jurisdiction. So you say that there is a compromise. But the ladies say that yes, there is a compromise. Then we
We
will on
join
compromise,
petition.
will following 498, we can do it, Lakshmi Narayan.
Lakshmi.
But without her, can we do it?
Third day I contact the person. Again, I
Are you married again?
he also
Oh, you also married. Bring her, we'll pass it.
I contact
You contact with your client or learned counsel.
client method at present. For the
Okay, for a case, otherwise he'll go to jail. Call him that instead of going to jail, come to Bongaigaon, meet your wife and file a joint application or ask their counsel to have instruction. We are in a revisional jurisdiction. Two courts has convicted you. Isn't it? Can we pass acquittal on the basis of that? We cannot. Even if we want, we cannot. Even if we believe that that is a genuine, then also we can. That
Yes.
is a statement from the council is necessary that yes, they are now separate.
Yes.
Bring the other side, okay, which is the other side,
Need for profit.
as we are.
Yes.
That boy who was in
member.
foreigner.
Yes.
His name is not Suprajot.
Super.
Okay. Okay.
Let them
All if-
appear, Lord.
Huh?
Let them appear. Fix the date.
When?
Second,
It is submitted by the learned counsel for the appellate that in the meantime, the victim has got married to some other person and the petitioner also married some other lady. And they have entered into, and they have amicably settled, both the petitioner and the victim has amicably settled the dispute amongst them and enter into an agreement. Got it registered before
for sub-register Bongaigaon.
sub-register Bongaigaon, being deed number
Deed number 25
2025
dated CB 12/2014.
3/12/2014. None appears, though none appears for the respondent wife on call, though the name of Mr. SBI is recorded. That being the position, Mr. S. adjourned and be listed.
So-
The the second week,
On third, 11 or 12.
11th of October
Lot.
2020. Madam, give a copy to her. I have an instructor whether it's genuine or
Lot.
from the subject. In the meantime, the learned additional public prosecutor may obtain the instruction from the sub-register Bongaigaon regarding execution and genuineness of deed number 20. Okay. Unnecessary deed
Lot.
certificate. You have an instruction. If genuine
Lot.
will allow on the basis of this, will keep the original as a part of it.
Lot.
My lord.
On 11.
Lot.
Registered, my lord.
Or both.
With copy of the order.
Copy of the order be filed. Copy of the order be filed.
Obliged.
Obliged.
Your senior is
Hospital.
it submitted that the arguing counsel is alive. Accordingly, prayer for adjournment is made, prayer is allowed, matter be set on again after 9. Yes, so that is 19th of October 20. Yes, Mr. Kotoki, for which method you are waiting? Not possible. You are also not interested.
Case of conviction under 489 C.
489.
Answer please.
This is no. What is this? Criminal revision.
Our non-contact type
This is item number,
48. Mine is 49.
but this is not your method. Non-appears for the petition. Not all. This method on October. If none appears to the not yet, the court shall proceed here the matter. It is accepted record and on merit in as much as the honorable effect of the case of it down by a proof of that criminal revision can be hard in absence the petition or it or these as are found that on and on. The prayer of Mr. P. Kotoki matter that on appeal is
Subject to lordship continues.
my convenience is after 9th of
Take time.
till 9.
Which one appreciation of
You have pardon me with that section 20.
Oh,
We can finish everything, but problem is that we have to continue the other part in the chamber, na?
Yes.
Yes, when 16th of yes, that also.
Actually, have it on Thursday, my lord, because when it's a 10-year conviction and he is already behind the bar half, my lord, four plus. And the only point, my lord, the doctor in her deposition has stated, my lord, that the vagina has been torn. Whereas from the medical report, it seems, my lord, I have just now flagged marked it. It is not so much.
77.
37.
and immediate impeachment. That may not be possible. As agreed to better content. I will not be here from 22nd I will be here from 23rd till 8 from 9. So in the meantime, before 22nd, I have complete many orders. Let me be frank.
After
After
I'll file a IA.
the first time, that better, so that we can have the budget. File an I.
Have a